Coming at you fast and furious style. Welcome to Celebrity Saturday, the inaugural effort. I am Frank Bruno. Welcome to Frank Bruno Law. The inaugural Celebrity Saturday will be about Paul Walker. This gentleman, most well known for the Fast and Furious franchise, unfortunately passed away well before his time. Ironically, he died in a car crash at the age of 40. He was survived by a 15-year-old daughter and a girlfriend of 7 years, and he passed away before his time. Fortunately, Paul Walker made a will when he was 28 years old, the same year that he made the first movie in the franchise. He relied on a will and a revocable living trust. But because he did not fund his trust during his life, all of his assets became public. The probate filing reveals that he was worth about $25 million. He had $8 million in personal property, cash and investments. He had $8.5 million in expected income, and he had another $8.5 million in real estate after subtracting mortgages. The probate filing shows that he had a revocable living trust benefiting his daughter as the sole beneficiary. Trusts are private documents. Wills are public documents. So we got to see the will, but we didn't see the trust. The probate documents reveal that the trust exists and that his daughter Meadow is the sole beneficiary of it. Instead of naming Meadow's mother as the guardian, he named his own mother, the grandmother, as the guardian of Meadow. Now, there's a few takeaways from the estate of Paul Walker. The first one is, he placed his trust in a trust. Having a will is only the start. A revocable living trust is probably the best estate planning tool for most people. It's a probate avoidance tool. Paul Walker left his assets to a trust. So therefore, even though he had to go through probate, it would be less burdensome than in many other cases. Hopefully, since he had a young daughter, 15 years old, hopefully that the trust spread out the money to her over her life or over a period of time and not causing her to get it just at 18 years old. Now, if you go to a good estate planning attorney, we would expect that that would be counseled and it would be thought of. But we don't actually know what happened because the trust portion of this is a private document. Now, another takeaway is that trusts have to be fully funded during your life. The reason we know that Walker had a will and the $25 million in assets is because he didn't fully fund his trust. When trusts are fully funded, meaning that all of your assets in your personal name are transferred into the name of the trust during your lifetime, then there's nothing left to pass through a will. This means that there doesn't even have to be a probate, and the surrogates court, the probate court, doesn't have to be involved and can be avoided. Instead, Paul Walker relied on his will, and he had what we call a pour-over will, and that means that the end result is the same, but everything that wasn't in the trust was to be placed into the trust upon his death. However, he's a celebrity, public scrutiny, the hassles are there, the taxes are there. If he had done proper planning or funding in advance, his family's affair could have been kept private and off of the public record. So he did great things. He named a guardian for his child. It's always a good idea to name a guardian for your minor child. So Meadow has a mother, and does that mean that Meadow's mother will lose custody of her? No. Not necessarily. The law still favors the custodial parent, meaning that Paul Walker's mother, right, his daughter's grandmother, will take over guardianship. She won't take over guardianship unless the mother agrees or is found to be unfit. But it was still smart for Paul Walker to address guardianship. You know, in case the mother isn't able to, she wasn't suitable, or she lost custody for any reason, or if she had been in the car with Paul. So she might have had a drinking problem. That's speculation, rumor, you know. Well, and we don't know if Meadow was living with the grandmother, living with the mother. But because it's a celebrity, many of these things may not be accurate, but it was good to address the guardianship. Another great point. Don't wait until you're too old to estate plan. Paul Walker made the will when he was only 28 years old. Like I mentioned, it was the year that he first made the Fast and Furious movie, right? He's to be commended for preparing a will at that young age. And he wasn't really a well-known movie star. Far too many people wait until someday. Someday I'm going to prepare a will. So you really shouldn't procrastinate with estate planning. And why? Paul Walker certainly didn't plan on passing away at the age of 40 in a car accident. So wills, trusts, other documents need to be updated. Fantastic, he planned ahead, but he failed to update his estate planning before he died. He died 12 years after he made his will. So many changes happened in the course of 12 years, especially when he rose to fame. His net worth grew, right? And he was relying on an old document. Now, looks like it worked out okay. However, things changed. Did he want his young daughter to inherit so much at a young age? What about his girlfriend? He lived with someone reportedly for 7 years. They planned on marrying. From what we know, the sole beneficiary was his daughter. What happened to his girlfriend of 7 years? They were planning to be married. Right? What if his mother was still no longer able to act as the guardian or the executor? His father was the executor. So these plans need to be revisited. They need to be updated. Now, Paul Walker could have made other arrangements for his girlfriend, a joint bank account, life insurance policy. These wishes wouldn't have been expressed in a will, could be in a trust. But one thing I'd like to mention is that his $25 million is over the federal tax threshold limit. And, you know, he could have taken advantage of any number of tax avoidance strategies to reduce the estate tax bill, but he didn't. So the estate went through probate, and ultimately it will lessen the amount of money that his daughter would have, right? Because the estate had to pay taxes. So these are all good takeaways. Kudos to Paul Walker. He did plan. There's a few things that we could have done differently. He could have revisited it, right? He could have used advanced tax avoidance strategies. But overall, this is an estate planning win. So if you'd like to speak to me about your particular case, or even if you have any questions, please go to frank@frankbrunolaw.com. You can send me an email. Thank you.